Move to Senate Bill 6298. Have a briefing from Luke and then hear from our prime sponsor.
Thank you, Madam Chair, members of the committee, Luke Wickham, committee counsel, and as the chair indicated, Senate Bill 6298 relates to the duty of clergy to report child abuse and neglect. By way of background, current law requires a number of different individuals to report child abuse and neglect when that person has reasonable cause to believe that a child has suffered abuse or neglect, and report that to the proper law enforcement or to the Department of Children, Youth, and Families. These specified individuals are often referred to as mandated reporters, and a complete list of those professions required to make those reports is included in the bill analysis. Some examples of those mandated reporters include physicians, law enforcement officers, school personnel, and nurses, among many others. A mandated reporter who knowingly fails to make a report is guilty of a gross misdemeanor. Senate Bill 6298 requires members of the clergy to report child abuse or neglect when that clergy member has reasonable cause to believe that a child has suffered abuse or neglect, except with regard to information that a clergy member obtains in that person's professional character as a religious or spiritual advisor, when the information is obtained solely in the context of a penitential communication. A penitential communication is defined in the bill as a communication that is communicated through spoken word, made privately to an individual member of the clergy, intended by the communicant to be an act of contrition or a matter of conscience, intended by both parties to be confidential at the time the communication is made, is initiated by the communicant, and made in the manner and context that places the member of the clergy specifically and strictly under a level of confidentiality that is considered inviolate by the religious doctrine of the member of the clergy. Members of the clergy must warn the Department of Children, Youth, and Families or law enforcement when they have reasonable cause to believe that a child is at imminent risk of being abused or neglected, even if that belief is informed by information obtained in part as a result of a penitential communication. That concludes my remarks.
Thank you. Any questions for staff? Representative Eslick.
I couldn't let this go by without asking. Penitential, does that specifically mean the Catholic priest, or does that also include other ministries?
The bill defines penitential communication, and that's the definition that I just went through. It does not specify any particular religion, but requires that all of those components that I just described be present.
Thank you. Additional questions, Representative Ortiz-Self?
Thank you, Madam Chair. Luke, so for clarification, someone can go to a member of clergy and under what seems to be a confidential agreement, confess abusing a child, and that clergy warns the department, and how is that different from being a mandatory reporter and putting in a report? And do they have to warn them? Is that mandatory, or is that, can you help clarify that, please?
Sure. So the current mandated reporting requires certain professions to report when they have information that they believe a child has suffered child abuse or neglect. The bill extends that requirement to clergy, but exempts information that clergy member received during a penitential communication. But if a clergy member received information that that leads them to believe that the child is in imminent risk of being abused or neglected, then that clergy member is required to warn either law enforcement or the Department of Children, Youth, and Families.
Thank you, Madam Chair. So just to get it straight, so if they receive the information in that penitential,
Yes.
in that penitential setting,
Yes.
they don't have to do anything. But if they hear it somewhere else, they have to warn?
So if they receive information that they think a child has suffered abuse or neglect, they are required to report that, except if they receive it during the penitential communication. But they are required to warn the department, even if they get information during that penitential communication that makes them believe that a child is at imminent risk of being abused.
And is there any guidelines on the, I'm sorry, Madam Chair, follow up? Is there any guidelines as to what does that warning mechanism look like? And how does it differ from a mandatory reporter?
The bill just requires that they warn when they have reasonable cause to believe that a child is at imminent risk of being abused or neglected.
Thank you. Mr. Vice Chair for testimony. Oh, sorry. Yes, just kidding. Senator Frame, thank you for being with us and for, waiting with us. Good to see you.
Thank you, Madam Chair, Madam Ranking Member, and esteemed colleagues of the committee. For the record, Noelle Frame, State Senator from the 36th District. Thank you, Luke, for that excellent briefing, as always. And colleagues, I'm going to spend a little time with you this morning to really walk through the differences of this bill from last year and compare to how it is different from current law and kind of what it does and does not change in current law, because points of confusion have been illuminated through this process, and I will endeavor to answer some of the questions I've heard this morning. I will also note, as you all already know, that this bill is very personal for me as a survivor of childhood sexual abuse that only stopped when I told a mandated reporter, which is a teacher. So I shall endeavor to keep it together this morning, Madam Chair, but apologies in advance if I cannot. So I wanted to start off by saying that it's really important to note that the bill before you is a very carefully constructed compromise developed with the Catholic Conference, who I'll note opposed the version of the bill that this committee and the House of Representatives passed last year. But I worked with the Catholic Conference and victims and survivors, particularly those of the Jehovah's Witness cover-up, who asked me to find a middle path this year so that we could protect the most children possible and not let the perfect be the enemy of the good. And so that is the bill that I have before you. This bill requires that clergy and other religious leaders become mandated reporters of child abuse and neglect. This year, that definition of a religious leader includes elders, and we ensured that that definition was specific enough that it covered the very cases, again, in the Jehovah's Witness community, which was at the center of the coverage from Investigate West in late 2022 that revealed decades of cover-up of sexual abuse of children. We also developed this definition of elder in consultation with our Native American tribes here in Washington State, thanks to the great work of my co-sponsor, Senator Claudia Kaufman. There is, as you have heard, an exemption for penitential communication. And while it is commonly understood as confession in the Catholic tradition, thank you for that question, Madam Ranking Member, the definition is applicable to all faith traditions, as Luke explained. While the bill that we sent you from the Senate last year had an exemption, it was overly broad. And the legislation before you now has an exemption that is very specifically and narrowly defined. Last year, of course, you all on the committee removed that exemption entirely and defended that decision vigorously on the floor on both sides of the aisle. And I want to commend you for that and tell you how so personally grateful I am that you all did that last year. But Madam Chair, as we all know now, I couldn't pass that bill in the Senate. I didn't have the support of my Senate colleagues to pass that version of the bill. So the bill before you is a compromise, and I encourage you to stick with the compromise approach that I've developed, because it is the version of the bill that I can pass this year, and I hope we can get it across the finish line. I will say I hope that, like me, you'll find comfort in the fact that we have paired this duty to report with its penitential communication exemption with this new duty to warn For religious leaders who have reasonable to believe that the child is at imminent risk of harm, even if that belief is informed in part by what they've heard in penitential communication. And as you'll hear today, the Catholic Conference is neutral on that provision. This is a very, very delicate threading of the needle intended to provide a pathway to protect children without causing religious leaders to violate their faith traditions. And it's accomplished, and this is to your question, Representative Ortiz-Self, because we are not asking them to report what they know has already happened, but rather asking them to warn DCYF or law enforcement of what they believe may happen in the future. We believe that this is not violating their faith traditions. It is a reasonable belief, even if informed in part by what they heard in penitential communication. Because at the end of the day, I don't want them to have to ignore that part of their brain when they have other evidence outside of penitential communication that they think a child is at risk of harm. And the whole point is call it in and go check on that child. You don't need to know who the perpetrator is. That's current law. You call in what you know, and we're just asking them to warn law enforcement or DCYF so they can check on that kid. It is important to note, last 2 points, Madam Chair, I know I'm going long, but there are a lot of points of confusion that have come up on this bill. We do not currently have a mandated reporter law for religious leaders. This seems to be a point of confusion because religious leaders sometimes are mandated reporters because they're operating in a role that is a mandated reporter, like a teacher. But religious leaders, as religious leaders, are not mandated reporters. We're one of only 5 states in the nation where this is true. Finally, nothing about this bill affects whether or not someone would be compelled to testify in court. This has come up in the process. Well, if you have them warn law enforcement, they're going to be drug into court and they're going to have to testify to what they heard in penitential communication. Madam Chair, that is simply not true. We are not modifying that portion of the statute. The clergy penitent privilege for testimony still exists in current law. This bill is not modifying that. The whole point is it is the duty to report and warn and protect children. That's it. With that, Madam Chair and committee members, thank you very much for your attention this morning. I'm going to stick around during testimony in case you all have any other questions, and I'm happy to take questions now. Thank you, Madam Chair.
Your dogged commitment to this legislation. There is a question, Representative Ortiz-Self.
Thank you, Madam Chair. Hello, Senator Frame. I know how deeply personal this is to you, and thank you for being here and sharing this with us again. Can you help me understand the difference between warning and a mandatory reporter? So, in other words, we know there are some penalties for being a mandatory reporter, and ignoring that as an educator, I'm very much aware of that. And I know, and the emphasis that is put on mandatory reporter, it is not optional, you do it. And we're using the word warning. Can you help me understand what the implications are if that isn't followed through?
That's actually a great question that I actually have to have Luke speak to if the penalties associated with duty to report extend to the duty to warn. That is a really great question, Representative Ortiz-Self. So I would want Luke to answer that. I think I've answered the question about the distinction between the two in terms of its practice, but in terms of the consequences, I would love for Luke to respond to that.
There is a statute that makes failing to a mandated reporter failing to report child abuse and neglect a gross misdemeanor because it uses the word report versus warn. My guess is that that would not apply in this situation.
So I'll offer, if it's okay, Madam Chair, I would need to kind of check with all parties involved, but if there is an amendment necessary, that is not a distinction and an issue that came up during the Senate proceedings. But I'm happy to have conversations about that if that's of interest to the committee.
Thanks very much. Representative Walsh with a question.
Thank you, Madam Chair. Thank you, Senator Frame. I think the work you've done on this is admirable and worthy. I've heard from some interested people on this issue who are not from the Catholic faith tradition, but are from other faith traditions. They are concerned about 2 points in this proposal. One is that there may be an establishment clause issue on some of the language around penitential communication because it is so narrowly drafted toward the Catholic faith tradition. And the other is that the definition of imminent risk is, I guess, not broad enough, would need to be opened up to the risk to the child. I understand how carefully you've worked to thread the needle on this language, but is there room perhaps to discuss some language changes that would broaden the notion of penitential communications slightly to include other faith traditions, and then separately maybe to do something with the definition of imminent risk to broaden it also?
Thank you, Representative Walsh, for those questions. I am certainly open to those conversations. Those two concerns have not been raised to me in this process, nor in public hearings, nor by colleagues in the Senate on the floor. So it is the first I've heard of it. As I'm listening to you, I feel like the spirit of what you're asking me to do aligns with the spirit of the bill. And so I'm certainly open to a conversation. I have worked very diligently to do this work side by side with survivors. So I will need to consult with them in this process as well, but open to the conversation. And thank you for the question, Representative Walsh.
Thanks. We can talk offline separately.
Thank you. Testimony, Mr. Vice Chair.
Thank you, Madam Chair. We have our first panel, who I believe is here in person. If we could have Timothy Law, Peter Inslee, Mary Dispenza, and Robert Fontana please come up to the podium.
Robert will be testifying remotely.
Sounds great.
Whoever would like to begin, please do.
Thank you, Committee Chair. Good morning, and to the Chair and to committee members. My name is Tim Law, and I'm with the Catholic Accountability Project and also Ending Clergy Abuse. We oppose 6298 because of the potential communication exception. We assert, and the questions that have been asked reveal the confusion about that exception. We assert that including this exception is primarily for the benefit of the churches and primarily for the benefit of the Catholic Church at the expense of the safety of children. The church is demanding a special privilege in this bill that would protect child abusers without a corresponding duty to disclose to the people of this state the files and information regarding the sexual abuse of our children. We have reliable information and belief that presently the Attorney General has served subpoenas upon the three bishops of the state, Archbishop Paul Etchen of Seattle, Bishop Joseph Tyson of Yakima, and Bishop Thomas Daly of Spokane. We suggest that we wait until this investigation report by the AG is made before consideration to see whether the church is entitled to these special privileges. They want perks without responsibility. They want a privilege without a duty to disclose. And we believe that this vote should be delayed this year until we have the full results of that investigation so that we can have a full consideration of this issue. And perhaps legislatures then, in light of that report, may have a different view about whether the church is entitled to these privileges.
Thank you. Welcome, Mary.
Good morning, everyone. Good morning, Madam Chair. I was raped by a priest when I was 7. As a young woman and a former nun, I told the priest in confession about my childhood rape by the priest. The crime remained silent and secret. The priest went on for 5 decades to rape at least 45 other little girls. Mandated reporting of crimes of neglect and abuse of children and vulnerable adults by clergy is a duty, not a privilege. It would stop generations of abuse in families and churches. Criminal acts against children and vulnerable adults are never privileged and secret information. This loophole protects abusers, not children. Thank you.
Thank you.
My name is Peter Isley. I'm also a survivor of sexual rape and assault by a Catholic priest when I was a child. I'm one of the founders of the Survivors Network of Those Abused by Priests. Some 32 years ago, we founded the organization. It's literally tens of thousands of survivors from around the world. I also operated a treatment center for victims of clergy sexual abuse, an inpatient treatment center, for several years. There's 3 reasons why you need to do what you did before and remove this exemption and this privilege from this bill. Archbishop Achin of Seattle gave you 2 compelling reasons this week. It's on video. We taped a conversation with him. I think we've sent it all to you. As Tim mentioned, in August, the Attorney General appears to have issued statewide subpoenas to the 3 dioceses to get their tens of thousands of pages of criminal evidence that are in all of their files, tens of thousands of pages of criminal evidence of the systematic and widespread abuse, rape, and assault of children and the cover-up of those crimes by the religious leaders of this state. It includes their admission, 151 priests and nuns who raped and sexually assaulted children over the past several decades in this state. None of them were reported. None of them faced prosecution. He won't tell us why he is not cooperating with this Attorney General investigation. Why would you pass a bill that trusts and gives special privilege to bishops and an organization that will not cooperate with a statewide child abuse investigation? In 1962, clergy were mandated reporters in this state. In 1975, they were removed. Take a look at the tens of thousands of pages of rape and assault and criminal evidence in those files, and you're going to see the result of that decision.
Thank you very much for coming forward. Appreciate it. Mr. Vice Chair.
And it looks like we have Robert Fontana ready on virtual. Robert, go ahead and unmute yourself and start whenever you're ready.
Good morning. I'm here in opposition to the penitential communication exemption. I appreciate Senator Frame's effort at threading the needle. I have worked in ministry in the Catholic Church since 1981, first at a parish, then at a diocese, currently as a director of a small Catholic nonprofit. While working at the Diocese of Yakima, I learned how clergy use the seal of confession to excuse their sexual acting out and protect each other from being discovered. I learned how priests who molest children and sexually assault seminarians and other vulnerable adults confess their sins to one another and continue with their criminal behavior. Part of my work in my nonprofit is a clinical practice as a marriage and family therapist. I am legally bound to confidentiality with my clients unless I learn from my clients that there's a risk of harm to either my client or to someone else. Clergy can and should be held to the same standard. I support making clergy mandated reporters without the confessional exception. Thank you.
Thank you. Mr. Vice Chair.
Thank you, Madam Chair. If we could now have Cristina De Leon please come up to the podium for testimony. And on deck, we'll have Jean Hill.
Hello, good morning, everybody. My name is Cristiana De Leon. I'm in Black Diamond, and I'm also a member of the Association of Secular Elected Officials, which, long story short, just means that you can be a good policymaker without a God. But why I'm here today is it's a very, very, very uncomfortable pro that I signed in. And it is because of every part of this confusion we've heard today, and especially because of the conversations we've heard from Senator Frame about this really delicate threading of the needle. I I really want to commend the House committee members in this room who really worked to close that exception and that loophole, to really make sure that there is no place where we should be protecting and aiding and abetting in child abuse. It is unconscionable to me. So I've also gotten a chance to work with Senator Frame, with the survivors from the Jehovah's Witness, but also with the folks that you just heard from today, and really hear their absolutely horrific stories of survivorship and how they have been demanding justice for decades. And these are people who are still practicing members of their faith. But what they want is they want to feel safe, and they want future generations to feel safe in their church. And to me, that's also what the First Amendment means, is that you should be able to go into a house of worship and not have a sense of mistrust that either you, another vulnerable individual, a child who doesn't have the full autonomy to fully choose their religion, you should not have to think that they are going to be put in a place of danger, or that who is administering their deeply held beliefs is somebody who's actually part of a cover-up. I hope that we can pass this bill by removing that kind of exemption. I appreciate the work that was done last session on 5280, I believe it was, to really close that loophole. If there's a way that we can get that across the finish line in that kind of form this session on the Senate side, I would be all for it. And in the meantime, to Senator Frame's point, this is a lot of harm reduction. This is about how we try to make sure that we're still trying to benefit the most number of children in this state. And thank you for your work on this.
Thank you. Welcome.
Thank you. Thank you, Chair Sen. Thank you, committee members. Jean Welch Hill. I represent the Washington State Catholic Conference, which is the 5 bishops of the state and the 1 million Catholics that they shepherd across the state. We do support the mandatory reporting requirements for clergy, with the exception of penitential communications in this bill. While the duty to warn provision on its face could require breaking the seal of confession, we are neutral on this position, as Senator Frame mentioned, since with our strong safe environment protocols and policies, clergy, lay employees, and volunteers should all be reporting reasonable suspicions of abuse based on witness conduct long before confession. No, they are not mandatory reporters currently in law, but in terms of our policies, we do consider them mandatory reporters. And I think that has gotten to be part of the confusion, that they are not legally required at this point, but we support that legal requirement. In the rare circumstance when a priest receives information in the confessional, the priest has a sacred duty to help penitent persons in their act of penance to seek atonement for past sins, to change their lives, and to avoid future sins. Normally, this would include removing themselves from any access to the child, seeking professional counseling, and self-reporting to authorities. No priest has authority to violate canon law by breaking the seal of confession. Similarly, we know of no priest today who would allow known child abuse to persist and a known perpetrator to continue to jeopardize their immortal soul after that person has reached out for help in the sacrament of confession. The broader exemption for penitential communications in the bill is critical to protect the sacrament of confession from state intrusion as required by the First Amendment. The duty to warn is an intrusion, but can be avoided by following our safe environment policies and pastoral care of a penitent confessing to ongoing sinfulness. We appreciate Senator Frame's efforts to thread this very difficult needle, and we are in support of mandatory reporting with the penitential communication exemption. Thank you.
Thank you. Question from Representative Couture.
Thank you, Madam Chair. Ms. Hill, in the bill, the way I read it, it clearly it tries to clearly define what is penitential confession and what is not.
Right.
So just for clarity, in the Catholic Conference's opinion, in your opinion, does this bill as written right now break the seal of confession?
Again, Section 6 potentially could. There could be a moment. Again, the duty to warn could do that, but again, that's why we agree to the in part language, because really if a priest is seeing activity outside of the confessional, that's what he should be reporting. And if it is within the confessional that he gets confirmation, our expectation is that he would report the activity he saw outside of the confessional, not what was actually said in the confessional. But that's sort of the reminder that you needed to report these actions that you already saw.
Thank you.
Thank you. I have a couple questions. So you did just mention that you were in favor of being mandatory reporters with the, so in the bill, it doesn't say mandatory reporter, it says mandatory warning. do you agree, or are you okay if it's a report versus a warn?
That language for us, that will make a difference legally. In terms of what happens in the confessional, it doesn't change what happens either way.
Okay. And do you support having the similar consequences that a mandatory reporter has, that a mandatory warner has?
I don't think we have an issue. Again, I think there's some legal questions that need to be answered with that. It's my understanding there is a Ninth Circuit opinion perhaps about that duty to warn and creating a separate duty for one group of people that is not applied to others. But that's for lawyers to consider. I'm a recovering attorney, so I don't practice here. But
Thank you. Any further questions? Okay, thank you. Mr. Vice Chair?
Thank you, Madam Chair. And I think we do have Sarah Pearson. If you could please come up.
Good morning. My name is Sarah Pearson. I'm a member of Ending Clergy Abuse, which is an international organization whose U.S. chapter is based here in Seattle, and I'm a part of the Catholic Accountability Project. And I'm here today to speak in opposition to Senate Bill 6298 because of that inclusion of the clergy penitential privilege. And myself and my colleagues are urging this committee to take similar action as was taken last year to abolish this privilege entirely. The church hasn't earned this privilege. This is not a new phenomenon. Records indicate that clergy sexual crimes date back to the 3rd century. And the seal of the confessional was actually created in the year 1215 to conceal clergy sex crimes from the public. The seal prevented prosecution of abusive priests, and it's a shame that something that was put in place in that specific time to conceal those crimes, which were public previous to that, is still being recognized in Washington state law in 2024. That shouldn't be happening. And in light of these subpoenas that were sent in August to the Catholic bishops, the legislature should not be giving the clergy this privilege intact when the church can't even say, we talked to Archbishop Achin on Wednesday, he can't even say if they're cooperating with the investigation. So they haven't earned that privilege. And I also do want to mention regarding the imminent risk, that's something that we also have concerns about. Something that's common is for the abuse victim to feel like they have committed a sin and committed a crime. They're often too young to understand what has really happened to them. And this language around imminent risk, it's common for a child to confess to having been abused in the confessional. So even if that priest has been removed and placed in a different parish, that particular child may not be at imminent risk, but all the other children who come into contact with that clergy very much are. That's a situation that we've seen over and over again that's caused decades of abuse when it should have been stopped earlier. So we urge you to strike this completely.
Thank you very much. Mr. Vice Chair.
Thank you, Madam Chair. We're going to move to remote testimony. It looks like we have Marino Harden. Please go ahead and unmute yourself, and whenever you're ready, go ahead.
Hello, my name is Marino Harden, and I was a Jehovah's Witness whistleblower in the Investigate West investigation, and I do support SB 6298. I am mostly concerned with clergy penitent privilege. The concept of mandatory reporting is intended to eliminate the bystander effect. I believe that the confessional exemption codifies the bystander effect. It's a very common issue we've seen with high control religious groups. They have this tendency to abuse clergy penitent privilege as a loophole to avoid reporting. Broad wording around confessional privilege has allowed religious organizations to just adjust their policies to require that all investigations be kept secret as part of their tenets and customs. And so a confession from a perpetrator, or a confession of inaction from a third party, or a request for help from the victim themselves, or even a full panel interrogation of the perpetrator for internal punishment, these are required in Jehovah's Witnesses or Scientology or LDS in some ways or others, and other groups. And they've all in court couched these as confessionals, and then the victim can't subpoena the documents, they can't compel testimony. I can provide multiple very recent court cases where Jehovah's Witnesses and Mormons have both used this defense in the last few years for not reporting large internal investigations. The following states have all made clergy into mandatory reporters without clergy penitent privilege: New Hampshire, North Carolina, Oklahoma, Rhode Island, Texas, West Virginia, and Guam. This year's compromise bill is less than we'd ideally like. It doesn't put us in a leading category like Texas, where there's no confessional privilege, but it does narrow the definition of confessional enough to cover most of the abuse cases that I'm familiar with as a Jehovah's Witness without breaking longstanding religious traditions. And it does help prevent couching of investigations, and the duty to warn would make our law better than average, not leading, but better than average, instead of where we are right now, which is one of the only states to not have mandatory reporting for clergy. Senator Frame has done a great job listening to our experiences, and this version of the bill with the narrow definition of confession does resolve most of the loopholes I brought up from last year's bill. I'm a hesitant pro for the sake of harm reduction in the community I come from, but the stories of the Catholic survivors are moving. Please don't settle for anything less than this compromise bill.
Thank you. Mr. Vice Chair.
Thank you, Madam Chair. Next, we have Rebecca Anderson. Rebecca, if you could please unmute yourself and go ahead whenever you're ready.
Can you hear me?
Yes, we can. Go ahead.
Awesome. Thank you. I'm so sorry. I was not able to get on Zoom, so thank you. Thank you for phones. My name is Rebecca Anderson, and thank you for your time this morning. This is a very difficult topic. I'm speaking today because protecting children is important. It is the responsibility of parents and communities, and if necessary, the government, to protect them from harm. And while there is much good in SB 6298, I am extremely concerned about an 18-word phrase that, if retained, will indicate that our state believes it alone has the power to save people. Specifically, the seal of confession needs to be honored and protected for the good of all of us. And so I'm beseeching you to strike the phrase from page 9, line 23, quote, even if that belief is informed by information obtained in part as a result of a penitential communication. This 18-word phrase is an attempt by the government to insert itself into the confessional along with the confessor and the penitent. The role of our government does not include dictating how a specific religion spiritually ministers to its people. To insist priests note a specific sin heard within the administer of the sacrament is wrong. If one sin is deemed to be by the government as admissible to authorities, then it leads to reason that all sins are at risk of being added to the list. As a Catholic, this greatly concerns me. Will government one day include my sins on some list that needs to be monitored? Unfortunately, we live in a broken world where people commit sins against each other, themselves, and ultimately against God. Mortal sin destroys charity in the heart of man by a grave violation of God's law. It turns man away from God, who is the ultimate end, and his beatitude by preferring an inferior good to him. However, the sacrament of confession is a sacrament of hope and healing. People who seek it are those who are remorseful for what they've done. They know they've broken relationship with God. A spiritual encounter with the divine physician, Jesus Christ, per the confessor in the confessional, can lead a penitent to make amends, restitution, and own up for their transgressions outside the bounds of the sacrament, and to accept the consequences of their sins. I am speaking today as a sinner who needs the seal of confession to be retained for me and for all sinners who meet Jesus, who is divine mercy,
Thank you
in the
so
confessional
much
to
for
restore their
joining us
relationship.
today. I know you can't see the recorder, but we are, or the stoplight, but we are at time. Thanks so much for joining us today.
All right. Thank you. God bless.
Mr. Vice Chair.
Thank you, Madam Chair. Next up, we'll have Teresa Schremp, and on deck, we'll have Sharon Hulling. Teresa, whenever you're ready, please go ahead.
Thank you very much. My name is Teresa Schremp, and I'm from the 43rd District in Seattle. I have no doubt that every person in this room and online is sincerely against child abuse and is committed to ending it. I would fully support this bill, but for the provision regarding the sacrament of reconciliation set forth in paragraph 6 on page 9. Confession is no small matter in the Catholic Church. If a Catholic fails to confess a serious sin, he is not absolved and is not assured of salvation. A priest can only absolve a sin if the penitent is genuinely remorseful and has resolved not to sin again. This rule is so inviolate that a priest who breaks the seal of confession is excommunicated. Section 6 provision is a blatant interference by the state in the spiritual practice of Catholics. Catholics who are aware of this requirement will likely not go to confession and will be deprived of the grace of God and the counsel of the priest. While protection of children should be paramount in our legal system, there are considerations which transcend even this issue. Nearly 60 years ago, the Supreme Court decided that an in-custody confession of a defendant should be excluded at trial if the defendant was not previously advised of his constitutional rights. So even though Mr. Miranda confessed to a brutal rape and kidnapping, the court held that his rights against self-incrimination prevailed over the state's interest in obtaining a confession. Notably, when Mr. Miranda was retried, he was convicted again, but without the confession. So will priests be required to administer Miranda-type warnings to those seeking absolution? This absurd question arises only if the state decides to meddle in strictly spiritual matters. In 1980, the United States Supreme Court observed that the priest penitent privilege recognizes the human need to disclose to a spiritual advisor in total and absolute confidence what are believed to be flawed acts or thoughts, and to receive priestly consolation and guidance in return.
Thank you,
Please vote
Teresa.
no.
Thank you very
Thank
much for
you.
joining us. Mr. Vice Chair.
Thank you, Madam Chair. Next, we have Sharon Hulling, and on deck, we'll have Michelle Amstead. Sharon, whenever you're ready, please go ahead. Michelle and then Alex. Sharon, are you on? All right, looks like we don't have Sharon. We'll move to Michelle Elmstead. Michelle, if you can hear us, please unmute yourself and go ahead whenever you're ready.
Hi, I'll try to make this quick. Sorry, I'm new at this. I'm a citizen, concerned. I'm a mother. I'm a grandmother. And I'm oddly going to speak bring up a couple things here that has not been considered yet.
Michelle, can
on
you
this
please
bill.
say your name for the record?
Michelle Olmstead. Sorry, I'm a little nervous. Okay. At first glance, I'd say that this bill would be good, of course. One more step to stop child abuse. But I want to know why we need this new law on the books. So I canvassed some churches and clergy in our local area. They already do this on a voluntary basis. They were very surprised that this was even being brought up. I wonder how this bill could possibly pass constitutional muster. Mandating anything for clergy or churches would certainly violate the separation of church and state. Of course, child abuse is horrible, wrecking lives, even extending to generational damage. The abused becoming abusers. In this bill, child abuse is defined as what any moral person would agree is legitimate abuse. But there's one area of abuse listed as female genital mutilation. Of course, that is certainly abuse. But here's the problem. How is that going to be rectified under this state's current consideration of gender identity, gender affirming care, and transition of children? Doctors, hospitals, and clinics that are performing these procedures and prescribing drugs that block puberty and transitioning are being held accountable for damages done to children under the ideology, which is considered child abuse by a large portion of the population, including clergy.
Thank you,
SB
Michelle. I'm going to have
62.
to ask you to wrap up.
Oh,
thank you
okay,
very
wrap
much
it up
for
really
joining us.
Oh.
Thank you so much.
I'm sorry.
Vice Chair.
Thank you, Madam Chair. And our last testifier is Alex Ashley. Alex, if you can hear us, please unmute yourself and go ahead.
Not look like we have Alex. So with that, we will go ahead and close the hearing on Senate Bill 6298.